Trial resumed. Majority Floor Leader.
Mr. President, may we recognize Miriam Defensor Santiago?
The lady senator from Iloilo is recognized.
Try and very humbly explain. Hello? For the second time, I would like to try and very humbly explain why the ruling of the court, as articulated by our presiding officer, is on all fours with our rules of court. Rule 16 governs motion to dismiss and deals with the separate grounds for filing a motion to dismiss. Here, the pertinent grounds are related to each other. You could file a motion to dismiss on the ground that the court has no jurisdiction over the person of the defending party, or that the court has no jurisdiction over the subject matter of the claim. With respect to jurisdiction over the person of the defending party, the Supreme Court has taught us it is a settled rule that the party cannot invoke the jurisdiction of a court to secure affirmative relief against his opponent, and after failing to obtain such relief, repudiate or question that same jurisdiction. So what we are being taught is that if you've already accepted jurisdiction of the court and you've even filed affirmative defenses for the consideration of that court, but your affirmative defense is denied, after doing that, you cannot turn around and then repudiate the same question of jurisdiction. Your hands are already tied. And then the other ground is that the court has no jurisdiction over the subject matter of the claim. Once more, to jurisprudence, we can turn and find the following lesson. While jurisdiction may be assailed at any stage, a party's active participation in the proceedings before a court without jurisdiction will stop ESTOP, will stop such party from assailing such lack of it. Again, the point is the same. You've already accepted jurisdiction, you've tried to obtain relief, and if you don't obtain it, you cannot now turn around and say, but after all, you have no jurisdiction over me. So I'm afraid that the ruling of the impeachment court that no preliminary hearing will be conducted on a special affirmative defense is on all fours with the rulings of our Supreme Court and the rulings as articulated by our President, our presiding officer, have always been totally congruent with the rulings of the Supreme Court.
Thank
Mr.
you.
President, Senator, may we recognize Senator Escudero, Mr. President, before you.
The gentleman from Sorsogon.
Thank you, Mr. President. With the permission of the presiding officer, may I address some questions to the lead defense counsel, Attorney Cuevas? Sir, if I may ask, it is clear that the impeachment court already made a ruling with respect to the motion for preliminary hearing and even on the affirmative defenses itself with respect to the jurisdiction of the Senate and the procedure adopted by the House. The basic concern, Attorney Cuevas, is you might call all 188 signatories, and you might end up, being bogged down on this issue that has already been decided upon and ruled by the Senate. That's a basic and valid concern by the impeachment court, sir. And secondly, if it was for the purpose of establishing the absence or presence of probable cause, as mentioned by Senator Santiago and ruled by the court in its written ruling, that has already been disposed of by the impeachment court. However, if the purpose is perhaps to set the tone or to, by way of preliminary, to lay the predicate for your general theory of the case, and you will not present 188 and perhaps one or two witnesses on this matter, perhaps some understanding or bending over backwards may be given. But the concern again, Attorney Cuevas, is baka yung buong 188 ho ay patawag ho ninyo. Ano ho ang balak ninyo?
That is far from my mind, Your Honor, because our attack is not on the number first. Now, secondly, I hope you pardon me for disagreeing with your dissertation that there was already a ruling on this particular case. May I cite the January 12, 2012 dispositive portion? In view of all the foregoing, the motion for preliminary hearing filed by Chief Justice Renato Corona is denied for want of merit. So what was denied in our understanding, and it is clear to us, is only the right to a preliminary hearing. not the affirmative defenses, Your Honor, please.
The court will decide on that, Attorney Cuevas. But may I get?
No, I'm just saying we have every reason to rely on this. If there was a categorical pronouncement, then probably we could have taken other remedies, Your Honor, please.
But may we know, Attorney Cuevas, on this issue and on this matter, in the absence of a pre-trial wherein we would have obtained the list of witnesses, insofar as this issue is concerned, who and how many witnesses do you intend to present, if you may know?
Well, we have stated earlier that we are presenting about 20 witnesses, Your Honor, all the entire impeachment proceedings.
On this topic, sir, Your Honor.
Now, on this topic, probably 3 up to 5. Because, for instance, in 3/4, 2/3, let's say there are this number, and 2 or 3 of them were intimidated or coerced to sign one way or the other. So the number representing at least 1/3 is already obliterated. So to us, that will be a facade of false information.
Mr. President,
Because you
Your
have
Honor.
a definite number in order to determine what is 1/3. Now, supposing of that 1/3, 1 or 2 were merely coerced, they were compelled to affix their signature without being voluntary on their part. Will that not at least change the color of their signature attached to the affixed to the complaint? That is because we have every reason to rely on the jurisprudence on the point. Since there is no definite article, much less any section of the impeachment rules by this honorable court, then we have to resort, or we have to go to other sources, Your Honor. And we are not totally left without any support whatsoever. What we read into the records are questions where the impeachment complaint was filed by at least 1/3. And to us, it is clear that the mere fact that the complaint is verified complaint was filed by at least 1/3 does not exempt the petitioner or the complainant from observing the requirements prescribed by law in order to comply with the requirements of due process. That is our point. Because left with no alternative, where do we go? There is no appeal. But there is a violation of the constitutional right of the accused. That is therefore a ground for the Supreme Court to take cognizance of the case. If that is a ground, then how else could we assert it? Except by pleadings. And if we do not agree with the decision of we do not agree with the decision of the Honorable Impeachment Court, then maybe other remedies are available to us.
Mr. President, for the record, I agree with the impeachment court with respect to the non-issuance of subpoena to members of the House. However, nothing bars a member of the House from testifying voluntarily if they are called by the defense as their witness.
No.
And insofar as allowing the defense to present evidence on this matter, for as long as it is on a short leash and will not entail the calling of all 188 of them, which would be unreasonable to say the least. And I think Council will agree with me.
Yeah, we have already. I'm sorry.
For the record, Mr. President, Your Honor, that is the position of this representation, so that the defense can be given some leeway with respect to developing their case.
I'm not yet crying for liberality in favor of the impeached public official. Many a times the prosecution had been crying for the extension of liberality on their part. If there is anybody who should cry or call for liberality, it should be the impeached public official, being the accused in a criminal case. Never is there a time where the prosecution asked for liberality. I was a fiscal for more than 20 years. I never asked for any liberality.
We submit and we thank the distinguished counsel for the defense for his
Thank you. Now,
patience,
may
Mr.
we
President,
pose a
Your Honor.
question, if Your Honor, please. We have 3 members of the House of Representatives whom we intend to utilize as adverse witnesses, Your Honor. If we call for a subpoena, if we ask for a subpoena to compel their appearance, Your Honor, it may again fall under the previous ruling of this Honorable Court. But this time, we are not calling them as ordinary witnesses, Your Honor. They are calling them as adverse party. And the law allows us under the rules of court, Your Honor.
Who are the adverse party that you want to...
For instance, Congressman Abaya, Your Honor, Congressman Kimpo, and Congressman Tanyada, Your Honor. And then we will dispense with
Mr. President, may we
Congressman
recognize,
Gonzales. We are calling them not in their capacity as congressman, Your Honor, but in their capacity as complainants, Your Honor. So they are adverse party, Your Honor. If the court will not lend its assistance to us, we'll have no alternative. We cannot compel them to come here.
All right.
Mr. President, may we recognize the minority leader, Senator Cayetano, and then Senator Drilon.
The minority floor leader.
Magandang hapon, Mr. President. Justice Cuevas, magandang hapon po.
Magandang hapon din po.